What is the real difference between European and American law? Hello, this is Reinhard von Hennigs, and this muting from board of this aircraft, which will bring me over to Europe today, is related to the question of intellectual property. There is a main difference between the American approach and the Central European approach, which is to differentiate between first in time versus first in use. So if you're the first one to file the proper trademark protection, for example, under American law, this is what the difference is. Filing means you have the right. Whereas in the European approach, it could be driven by the fact when you are first using it. Now the question in the global world is, how does China fit in? And China seems to have adopted the more American approach as in filing matters. And therefore I'm now curious how the global law will adjust between the two different tendencies. In any case, what really matters is not the question how the law is drafted, but how the law is enforced. And if we still do see American trademark enforcement as European trademark enforcement pretty stringent, whereas in certain Chinese settings or other Asian settings, the enforcement factor falls behind global standards. So what it means is also to look into how many Chinese trademarks and patents are filed globally. And while I see an interesting increase in numbers of patents and trademarks filed from China, I can only imagine it is a question of time when the Chinese authorities are starting to enforce trademark violations or patent violations as well. So in a nutshell, if you want to protect your intellectual property, file it and then use it.